parked on hotel, guest date, time of arrival, scheduled departure, the room number assigned, the rate charged, how they paid. Can you believe that crap? All this time, I thought they were taking my license plate when I check into a hotel, like, because they didn't want my car to get stolen. No, it's probably some, like, municipal ordinance where the cops come and they just take it. And so what's cool is some hotel owner challenged it on it's unconstitutional under the Fourth Amendment. And so they said, yeah, you can challenge the facial constitutionality of a Fourth Amendment statute. So I really like this because I don't like the police knowing when I'm staying at the Holiday Inn. That's my personal business for the most part. All right. Here's a good case. The police may not extend an otherwise completed traffic stop absent reasonable suspicion. And what's cool about this case is it was only like 7 to 8 minutes, and the Supreme Court's like, no, you got to let him go. So way back in the day, I'm talking the late 90s, we had a case in Texas where they said once the purpose of the stop is effectuated, you're free to go. And so now the Supreme Court has caught up to the great opinion by Judge Charles F. Baird. All right. Okay, I'm including this, although it seems like we would know that having a GPS tracker on our client is a search, right? So, oh, this one they put it on his vehicle. It's the next one. But what happened was they put the tracker on, but they didn't have a warrant, but later he consented to the search, so they're like, that's fine, because later he consented. All right. And this is another one where on the four corners of the affidavit, they had a dog sniff, which we know, Florida versus Jardines, they can't rely on if they go to your curtilage and stuff. But if there's enough on the four corners for probable cause, if we take away the improper dog sniff, then it's fine, right? Yes, exactly. Laughable. In this case, for those of you who follow this sort of stuff, last year or the year before, the Court of Criminal Appeals came out with a case that it wasn't reasonable suspicion to pull someone over who stayed in the left lane because there was no showing when the left lane for passing sign was, because the cop didn't say, look, he just passed it. In this case, it's like they're almost saying, hey, but don't think you can drive in the left lane without being suspicious. They're like, oh, so he drove by it and the cop was behind him, he saw the sign, but the guy stayed in the left lane, and then the cop's like, and he had more than enough chances to get over, but he didn't get over. It's exactly, and they watched the video, you can say, and we watched the video, and while, in hindsight, the officer's on the scene, and he's judging it by that, so we shouldn't judge it by the video, which totally belies our opinion, all right? And I will tell you, after having worked at the Court of Criminal Appeals, that they like nothing better than a video or audio tape because it's very boring. There's no people up there, so we're going to watch a videotape of a stop over and over. All right, tracking device is a search. Okay, sufficiency of the evidence. You all don't really worry about that, I guess, except if you're asking for a directed verdict or something like that. But this is sex offender registration that they sort of made the second part strict liability. So he knew or was reckless about his duty to register, and he failed to report in person. But there's no knowledge requirement for that second part. And in this case, I don't know if the guy was telling the truth or not, but he's like, well, I went down there and there was nobody to help me. And I went back the next day and there was nobody to help me. And they're like, oh yeah, too bad, you're going to prison. So there you go. Okay, this case is interesting only because I can't decide if they can go back and charge him if the statute of limitations. They charged a guy with filing a false mechanics lien, was it securing execution of a document? And their theory was by giving the lien and the clerk stamping it, they executed it. But the court's like, no, that's not executing it. What they really did was he induced a public servant to file. So they charged under the wrong statute. So the court's like, no, it's not sufficient. But do you think, Tom, that they can go back and charge him under the right part? Probably. Hopefully the statute of limitations is run. We can pray for that tonight. Add it to your list of prayers that the statute is run. All right. This is another case with bad facts make really bad law. So CPS like calls the cops and says, we think there's some child abuse going on in this home. So of course the officer calls the man and he says, oh yes, I have sexually assaulted my 11-month-old baby on 3 times, and then he calls her back to tell her about a 4th time, okay? And the only evidence they find to one of them, because he talks about he may have masturbated while engaging in something, and some semen may have fell on the floor. So they come and cut out the floor, the carpet, and they find some DNA. But that's only from one of the cases. So typically under the corpus delicti, you can't convict somebody with just their confession, right? Remember that from law school? Hold tight to that. That's one of our few good things. But the CCA has now an exception. Yeah, but this is just so bad. And it's all kind of closely related. So now they have this new exception. Closely related crimes exception. So because they had that DNA, all that other stuff, see, it's all together. So this guy, it's like, dude, why are you talking to the police? That's the first question. All right. Okay, I'm done with the recent cases, but I'm just going to tell you some pending cases. You know, when Miller versus Alabama came out and said, look, you can't keep juveniles without life without parole, right? So that's good, some good stuff. Well, apparently there's a bunch of juveniles, like they're now like 70 in Louisiana, and they're like, well, we don't have to release them. It's not retroactive. Yeah, so they're going to consider that case. Yeah, I know. It's like, really? You've not gotten your pound of flesh? Like, really? This is a great case. They're going to reconsider what is a neutral explanation under Batson. So, I encourage all of you to make those Batson claims. You know there's some discrimination out there every day, and I want to start seeing some Batson. You know how many times I've seen a Batson challenge in all my years of appellate work? 0. It's like a unicorn. I know it's out there, but I've not seen it. All right. In this case, they're going to consider, so you got some money, but you're charged with a crime, and so the government wants to keep your money so you can't hire a lawyer. But the money's not from ill-gotten gains. Can they do that? I mean, you don't need to grant cert for me to just say no. I could answer that, no. All right. And this is interesting for appellate types because they talk about sufficiency of the evidence and what you measure it against. And in the late 90s, the Court of Criminal Appeals changed like decades of precedent. It used to be the evidence was measured against the jury charge. And the jury charge should comport with the indictment. Then they said, oh, no, because now if there's a mistake in the jury charge, we're going to measure it against the hypothetically correct jury charge, which should have been given to the jury but wasn't. And so I'm wondering what's going to happen in this case and how I can use it in my future cases. So that's like my idea of a great day, like reading that case and waiting. All right? Oh, and in this case, it's just bizarre, and I know that's too big, and you'll be getting this, but it's like the judge, like, I think he tried the case where the guy got the death penalty, now he's on the Court of Appeals, and I think he encouraged them, he declined to recuse himself, and it's just like nuts. Why are judges so afraid to recuse themselves? It's like, no, I gotta be on there. I gotta be one of the ones voting that he get the needle, because I'm up for re-election next year. All right. And, okay, finally, off the new cases, all these cases are because people objected, for the most part. So please, I hear a lot of lawyers say, well, objections don't really work. I understand how they don't work in the trial. But later on, do it for me. I've done something for you, so do it for me. Thank you.